The tragic deaths of Amal, Umer and Nashwa over the past year made headlines. Yet, as protests in the days after Nashwa's death showed, medical malpractice is far from an isolated problem. To learn more about the legal issues surrounding medical malpractice, Team Soch spoke to lawyers that have represented patients as well as doctors in such cases.
In the most traditional sense, medical malpractice can be that a doctor who is treating a patient does something so negligently that it has caused harm to that patient, either caused the death of that patient or worsened that patient's symptoms in some way. But there are also certain other categories of medical malpractice. For example, until very recently, denial of service was also a huge problem here in Pakistan, where private institutions would refuse to treat patients in critical condition who would show up in their emergency wards and they would say, sorry, we can't treat you here, go to JPMC, and I mean, that's negligence, because in critical conditions, a patient sometimes has minutes, 5 minutes, 10 minutes is the difference between life and death. And if a hospital or a doctor or a team of doctors refuses to treat a patient, that's negligence too. And then I think there is a third category where prescription of drugs is a problem, where doctors feel that because of their arrangements with pharmaceutical companies, कुछ दवाएं हैं जो उनको प्रिस्क्राइब करनी है, मल्टीविटामिन देना है, वो 1200 रुपए की बोतल है, वो बैक इंजरी के साथ आया है, लेकिन मल्टीविटामिन आप प्रिस्क्राइब करें क्योंकि फार्मा कंपनी का उसमें फ़ायदा है. So that also is negligence.
So what does Pakistani law say about medical malpractice?
Medical malpractice laws can be divided into three categories, I would say. The first category would be your remedies against the medical practitioner. More specifically, that you can have the license of a medical practitioner revoked. So there is a remedy regarding a doctor's license to practice medicine, which you can go after as a result of any medical negligence. The second, of course, would be the license of the institution itself. So let's say, a patient was treated at a hospital. So that hospital stands to lose its license with the government of Sindh. And then thirdly, of course, there are penal liabilities in the sense that you can enforce monetary claims or criminal liability on the practitioner or the institution.
The three remedies to address medical malpractice sound great in theory, but are any of them actually accessible to ordinary Pakistanis? We take a look at them one by one. First, registering a complaint with the Pakistan Medical Commission. All medical practitioners are registered with the PMDC, the Pakistan Mental and Dental Council. So there is a remedy by lodging a complaint with the PMDC. कि जी इस डॉक्टर ने मुझे ट्रीट किया और वो नेग्लिजेंट था. The PMDC has a disciplinary committee and they can call the doctor, ask for an explanation, and if they feel that the doctor has acted negligently and against his code of ethics, they can suspend his license either permanently or temporarily. But those have their own drawbacks because the PMDC is not as efficient as one would like it to be. It's very difficult to make these complaints go into their disciplinary hearings and get adjudicated upon. In order to learn more about this process, Soch filed multiple requests with the PMC to provide statistics on the number of doctors against whom complaints have been registered in the last 5 years. We received no response. The second possible remedy is filing a complaint against the hospital with the Provincial Healthcare Commission, such as the Sindh Healthcare Commission.
The Sindh Healthcare Commission, Section 19 and 19 particularly looks at medical negligence. Sections preceding that look at the duties on the healthcare providers. Section 19 particularly talks about the healthcare providers, the Sindh Healthcare Commission taking cognizance of the healthcare providers' negligence. This could be of three types. It could either be that they have done or omitted to do something that was required of them. It could be that they do not have the kind of facilities that they project themselves to have, or that they or their employee has been negligent in the direct provision of healthcare. Section 20 of the Act also requires the Healthcare Commission to set up the standards of practice. But the commission took until last year to even become functional. Since then, the registration of hospitals with their commission has been at a ridiculously low rate. They've been giving extra time after extra time to hospitals. They have not set a hard deadline for registration. Until a hospital is registered, they do not have the capacity to go and inspect it. And because of that, a large part of the healthcare system, healthcare providers are all unregulated practically. And that alone leaves so much room for negligence and malpractice.
Again, in order to find out more, Soch filed a right to information request with the Sindh Healthcare Commission to provide information on the number of registered hospitals in the province and any action the commission had taken against negligent healthcare providers. Predictably, we received no response. The third remedy available in case of negligence is filing a criminal and/or civil suit.
Regarding civil claims, there is always the claim for damages, both under the Fatal Accidents Act and the tort of damages. कि जी एक hospital की, एक doctor की duty of care है कि वो हमें सही treatment दे. If he has breached that duty, if that breach has caused damage, so we are liable to claim compensation for that. तो ये एक civil claim होता है, इसमें वक्त लगता है, लेकिन it's essentially a claim for compensation. You can also lodge an FIR against the practitioner for medical negligence. It falls under section 300 of the Pakistan Penal Code. Although those are more difficult, criminal trials are more difficult to pursue.
The lack of accessible legal remedies may give the illusion of a system stacked against victims of malpractice. But the system in its current form doesn't really benefit doctors either.
Contrary to what the patient's lawyers may say, I think the doctor's feeling is that they are the ones who are unjustifiably persecuted when it comes to these issues, and they are not adequately protected. I mean, I've had one doctor who's had to attend like hours and hours of an evidentiary hearing, just repeating her answers again and again about a certain surgery. And because these are cases of medical malpractice, I mean, it can get quite heated, very time consuming, very taxing on doctors as well. You know, doctors in performing surgeries and stuff, these are high pressure situations, and they can't have the risk of litigation hanging over their heads while they're performing surgery, because they just won't perform then, and they should be given a degree of leeway. I've seen judgments like that in Pakistan as well, that you can't hold a doctor criminally negligent just because you think that a surgery didn't go your way. I've seen that, but on the other hand, I've also seen that courts go after doctors and say that, how can you do X, Y, or Z? Yeah, there needs to be a much more effective way for people to hold doctors accountable.
The exact process of holding doctors accountable varies around the world, but generally, many countries such as the UK, the US, Canada, and Australia, including Pakistan, follow a model based on English common law. Under this model, civil suits can be filed for damages based on loss of present and future earnings. However, unlike Pakistan's model, additional compensation can also be awarded based on pain and suffering caused by negligence. For instance, in December 2019, a woman in the state of Kentucky in the United States received $10.5 million in damages for a botched surgery, of which $9 million were awarded for mental and physical pain and suffering. Also unlike Pakistan, where the number of malpractice cases is hidden from public view but estimated to be extremely low, other countries are much more transparent in their disclosures. In the United Kingdom, for example, the National Health Services received over 10,000 negligence cases in 2018, resulting in payouts totaling more than £2 billion. In the same year in the United States, patients received a total of $4 billion in over 11,000 successful cases. Crucially, these countries also require malpractice insurance for doctors, provided either privately or through the government, to ensure they are not practicing under constant threat of financial ruin in case litigation does not go their way. In Pakistan, by contrast, malpractice insurance is only optional for doctors, even though it is available through private insurance companies under the category of professional indemnity insurance According to anecdotal evidence, it is rarely purchased, leaving doctors constantly vulnerable to the threat of costly and time-consuming litigation. But while mandatory malpractice insurance would undoubtedly benefit doctors, what could an accessible and effective solution to malpractice for patients look like in Pakistan?
So the realistic ones would perhaps, to start off with, would be that every practitioner across the board has to display their PMDC license, a certificate that says that they have been inspected by the Sindh Healthcare Commission, that they're registered, and then moving towards something that would be more ideal but perhaps requires more capacity is that the government should ensure that every year their all practitioners' licenses are suspended until they've done a refresher or they've taken a small exam that proves that they're up to date with the practice, that their competence levels are up to mark.
In an effort to crack down on one aspect of medical malpractice, the government of Sindh passed the Sindh Injured Persons Compulsory Medical Treatment Amal Umer Act in March 2019. Under the law, public and private hospitals can no longer refuse to treat patients based on their ability to pay or based on injuries that require legal formalities such as gunshot wounds. But most other aspects of malpractice in Pakistan still require urgent reform. Essentially, the choice faced by ordinary Pakistanis in case of malpractice is either pursuing the case with two non-transparent and unresponsive organizations in the form of PMC and provincial healthcare commissions, or be willing to fight an expensive and long drawn-out case in the courts. Which raises the question, what good are legal remedies if the finances and effort required to pursue them preclude most victims to begin with?